A very warm welcome to everyone to our afternoon panel on populism, constitutional degradation, and gender-based representation. My name is Mara Malagodi. I am a reader in law at the University of Warwick in the UK, and I will be chairing this afternoon session. We're joined today by 5 speakers, so unfortunately, one of the speakers on the program is unable to be with us today. I'm not going to make any remarks because I want us to use most of the time. Before I introduce our speakers who join me today, I wanted to say that if you have any questions for this morning's presentation, if you can send an email to the project's email, we'll be collecting comments and questions for the speakers and then redistribute them when they're in at the end of the conference. So without further ado, please let me introduce our speakers today and our betting order. So first we have A.Riccioli, who is a PhD student in comparative public law here at the University of Pisa. And she will be talking to us about gender backsliding as a de-democratization process with examples from Hungary and Poland. To my right, we're joined by Professor B.Arifi, who's Professor of Criminal Law and Criminology, Pro-Rector for Research and International Relations at the Faculty of Law at the Max van der Stoel Research Institute, Southeast European University in North Macedonia. Besa will be speaking to us about gender, rule of law, and institutions in North Macedonia. And then we're joined by C.Correndo, who's a postdoctoral student in the Faculty of Law at the University of Turin. Chiara will talk to us about shaping gender in India, legal navigation through the prism of women's rights. We're then joined by Gergana Tzvetkova, who's a postdoctoral research fellow at the University of Ca' Foscari in Venice, and will be speaking to us with respect to gender, a divider or a unifier for the Bulgarian left-wing and right-wing populism. And last but not least, we're joined by C.Magneschi, who's teaching in the School of Law, which is at the University Science for Peace at the University of Pisa. I'm translating simultaneously from Italian. I apologize if that's imprecise. Please correct me. And Chiara will talk to us about care, democracy, and the Constitution. Without further ado, I'll give the floor to Alessia and let me set up the PowerPoint. I need to share. Okay. Am I doing that right? All right, I go on to this one and minimize this. You have the remote. Myself.
Good afternoon. In this presentation, I will address the gender backlash phenomenon in Poland and Hungary. Gender backlash refers to the undermining of gender policies. It affects the state democratic structure, being part of the wider process of democratic backsliding, which has been defined as the state-led debilitation or elimination of any of the political institutions that sustain an existing democracy. Gender backlash has recently become an urgent topic over the past decade, especially after the economic crisis of 2008, albeit between the 1995 Beijing conference and 2008, gender policies have experienced an upward trend in Europe and beyond. The gender backlash phenomenon is consistent with the rise of populism worldwide, so for this analysis, it is necessary to underline to what extent populist regimes and gender backlash are linked. Populism has been described as a context-dependent notion and as an ideology with a thin center morphology. So populism has a restricted core, which could be combined with a narrow range of political concepts. The core of this narrow ideology is the appeal to the people, referring to the group that populist political forces want to represent against all the others. This dichotomy creates a bipolarization of society, which is used by populist political parties to get more political consent. In theory, populism does not have any kind of relation with gender issues, since the differences within the people group are irrelevant. However, populism obviously does not operate in a cultural or ideological vacuum. Especially radical right-wing populism tends to feminize the enemy and to refer to a strongman style of political leadership designed around the idea of hegemonic masculinity. Even though politics is generally considered a gender-neutral practice, masculinity could operate as a hidden human norm that structures politics. Consistently, populist right-wing parties consider the people in terms of biological essentialism, based on the idea that the traditional conjugal family is the natural cornerstone to society. A symptom of this phenomenon is the warfare against the so-called gender ideology, which is a rather confused concept that includes the movements for LGBTQI+ rights and women's equality, as well as those who do not agree with the naturalistic assumptions about gender and sexuality. Democratic backsliding has most strongly occurred in Central and Eastern Europe, especially but not only in Hungary and Poland, where the anti-gender criticism is focused on the notion of gender provided by the Istanbul Convention, which aims at preventing violence, especially the domestic one against women. In both these countries, the right-wing executive expressed its opposition to the convention. Hungary has signed the convention in March 2013, but the convention was never ratified. The reason is that Hungary has been ruled by the Fidesz party since 2010, and Viktor Orban is the prime minister since then. And this government affects the rule of law of the state, granting less protection to human rights, such as women's rights or sexual and gender minority rights. Consistently, the government refused to ratify the convention, which was regarded as inconsistent with the national constitutional identity of the country. In Poland, the Istanbul Convention was actually ratified in 2015, thanks to the Civic Platform Party, which ruled the country for two consecutive pro-European governments between 2007 and 2015. However, in the same year, the Law and Justice Party took the executive, and since then, the government has pursued the idea of withdrawing the convention. In 2020, the Polish Prime Minister filed a petition to the Constitutional Court asking to declare unconstitutional the Istanbul Convention under the allegation that the ideological background of the convention was inconsistent with the spirit of the national constitution, grounded on a binary and biological understanding of the sexes. There are different constitutional strategies which could be related to gender backlash, as already brilliantly explained by Professor Rubio Marin. While the constitutional entrenchment strategy has proven particularly useful in Hungary, constitutional erosion is more likely to happen in Poland, where the constitutional dynamic is different from Hungary, because here the government relies on increasingly government-backed courts to advance its political agenda. And in Hungary, a new constitution was approved in 2011, thanks to the two-thirds supermajority that the ruling party got. It is clear that the model of family embodied in the constitution is referred to the heterosexual and procreative family. And in 2012, the Constitutional Court tried to resist to the complete subversion of liberal values pursued by the government. But as a response, in 2013, the Constitution was amended, granting even more protection to the heterosexual and procreative family, as proven by the Article L, for example, and the review powers of the court were limited. So, as far as As far as Poland is concerned, as said before, courts are aligned with government. Even though the 1997 constitution was actually reformed in 2009 to entrench heterosexual marriage, in 2005, the Constitutional Court had already recognized the heterosexual marriage a distinct constitutional status, whose change could only take place via constitutional reform. In the same year, the Constitutional Court sanctioned Poland's duty of enhancing the bond between family members, especially between parents and children and between spouses. And in another 2011 judgment, the court stated that the only family model embodied in the Constitution was the lasting union between a man and a woman oriented towards motherhood and responsible parenthood, referring to the Article 18 of the Constitution that defines marriage. Thus, it is clear that both Hungarian and Polish constitution privilege an heterosexual model of family with a reproductive scope. The analysis of some critical issues is useful to better understand the gender policy decay which took place both in Hungary and Poland. So first of all, for both of them, the reference is to the European indicators provided by the Area H of the Beijing Platform for Action. For example, concerning the indicator on gender mainstreaming, Hungary and Poland both scored 0 out of a possible 12 against the European average of 5.1. And the main reason of that is the complete lack of data, but also the absence of any kind of commitment to gender mainstreaming. And as far as domestic violence is concerned, as said before, Hungary has never ratified the Istanbul Convention, and the Domestic Violence Act, adopted in 2009, provides only for civil protection order, also called preventive restraint. Domestic violence was not even a specific criminal offense in Hungary until the adoption of the new criminal code, which is entered into force in 2013. It's worth noting that it also applies to same-sex relationships. However, no protection is provided for women in couples who do not cohabit or in ex-couple who did not cohabit unless they had children with the perpetrator. In addition, sexual violence is not regarded as domestic violence, but there is a separate offense for it. The Hungarian law does not provide public prosecution for rape and sexual violence, and it is significant that the definition of sexual violence does not refer to the lack of the victim's consent, but to coercion. Unsurprisingly, Human Rights Watch described domestic violence against women in Hungary as a chronic issue. Moreover, the challenge to gender equality has been particularly significant in the family policies area. Hungary tried to reach demographic sustainability, referring to an appropriate model of working family, enforcing the role of women as the mere caregivers of the family and preventing women from finding a job, especially during pregnancy or during the 3-year-long parental leave. However, this policy has actually changed after 2016 due to the governmental choice of boosting the fertility rate through the labor market participation of women. Finally, in Hungary, an erosion of consultation mechanisms occurred, resulting in the exclusion of women's rights groups from the policymaking process, despite the non-feminist conservative women organizations are included in constitutional patterns. The main reference is to the Women's Rights Thematic Working Group, which is a consulting body headed by the minister responsible for family affairs, who is responsible for gender equality policies at national level. As far as Poland is concerned, a critical issue is abortion. The main reference is to the 1993 Act on Pregnancy Planning that regulates the abortion in the country. And it has been recently amended in 2021, confirming the Polish abortion legislation as one of the most severe in Europe. And unsurprisingly, this change was anticipated by the Constitutional Court's decision adopted in 2020 that stated that abortion was illegal even in the case of severe fetal abnormalities. In addition, already in 2016, the National Prosecution Office reinterpreted the offense concerning abortion extensively, considering an offense not only giving any kind of information on abortion in the country, but abroad as well. And gender backlash could also result in a process called undermining implementation, which means that the institution aimed at advancing these policies remain untouched, but they are no longer effective. They have no longer effective power. For example, the budget of Polish ombudsman was widely reduced in 2016, being associated by the government to the promotion of gender ideology. And in addition, the Gender Equality Policy Agency, called the Office of Plenipotentiary for Equal Treatment, was merged with the Plenipotentiary for Civil Society under the name of Plenipotentiary for Civil Society and Equal Treatment, but unsurprisingly, the new portfolio was assigned only to the civil society issues. So in conclusion, anti-genderism is politically effective due to its relationship with the right-wing populism. Anti-gender campaigns have succeeded in spreading with a right-wing political framework whereby populist parties borrow ideological tools to achieve political hegemony. The current wave of right-wing populism in Europe combines conservatism with criticism to neoliberalism and globalization. In Central and Eastern Europe, gender ideology has been perceived as the symbol of European Western colonialism, against which gender traditionalism became a form of resistance. Anti-gender campaigns are therefore symptomatic of a conflict of values that challenges the role of the state and its democratic structure. So considering the ongoing democracy decay, it seems increasingly necessary to contribute to the constitutional debate in a supranational or at least European dimension. Thank you.
Thank you so much, Alessia. Let me set up the PowerPoint if I manage for Besa. This one. Okay. Back to the other one. Where was I? I was here. Yeah. Okay. No.
Thank you very much. Thank you, first of all, to the organizers of this event, EU Wonder. It's really a pleasure to be here, and it's really an interesting conference that I really enjoyed in the morning session and now with this panel. And thank you for accepting also my paper to be presented here. So I'm B.Arifi. I come from Southeast European University at North Macedonia, and today I will be talking about the Yeah, I will be talking about my paper, Gender, Rule of Law and Institutions in North Macedonia. Having in mind that this topic is a general one and can be addressed in the spectrum of many countries, I will share the North Macedonian example regarding to gender backlash and constitutional degradation. So mainly my paper consists of three main points. It analyzes the populism, gender rights, and the correlation between populism and anti-gender movements. Then I analyze the approach towards gender-based violence in Republic of North Macedonia, analyzing some problems there. And because hate crimes are my specialty, I focus a bit on the gender-based hate crimes and how that reflects to gender-based violence in my country. So There are a few topics that can be more uniting for right-wing conservative populists than those referring to gender, gender identity, and LGBT rights. In my country, on 29th of June this year, a protest took place in the center of Skopje. And all these kind of protests emerged from a group of citizens who actually represent themselves as concerned citizens in regard to what is happening to our youth and our children. It all started with reactions against sexual education in school, which was planned to be implemented by the social democratic government in power, but it gave the place to protests organized by the Orthodox Church, but they were supported by all religious communities in North Macedonia, which actually were protests against two important laws that were to enter the parliamentary procedure. These are the law on gender equality, and the second is the law on civil registry. The first one is it makes a clear distinction and gives a precise definition of gender, and the distinction between sex and gender identity, whereas the second law addresses the problem of people being able to change their gender in the civil registry. So these two laws were seen as very problematic, especially by the religious communities. What was interesting was to attend the narrative in those protests. I mean, for example, the head of the Macedonian Orthodox Church said that women do not want fake rights or fake identity, and other narratives that actually relate to anti-gender movement around the world were used there as well, such as discrimination against the majority, which is done by a minority of people, the silent majority, which is actually opposed to the gender theory as they underline it, and the undermining of family values, and how to say, the tendency to present the children as the most vulnerable group of this kind of movements. So what is important is that in North Macedonia, during the previous time, I mean during the when the right-wing political party was in power between 2006 and 2016, this kind of narratives were not so evident because the government stayed out of the gender, how to say, discourse and policies and debate in general. But when the Social Democrats came to power, they tried to address this problem and to make space for people to present their gender identity as they wish. But however, they were confronted by this group of anti-genders people, and that makes them also vulnerable. I mean, the progressive parties, if I may say so, it puts them in a vulnerable position, because actually these are things that relate to populism, and populist parties are usually more how to say, successful in North Macedonia, in Western Balkans, but also elsewhere, as we can see. Here I have two different photos that of events that took place in North Macedonia during the same year. So the first photo was taken during the anti-gender protest organized by the church, and the second one is the gay pride in Skopje in 2023. So one of the researchers that I interviewed for this paper made a very important distinction, saying that if you look at the people who attend these kind of movements, you can see a lot of differences. The first protest was mostly attended by middle-aged men, but also some women that showed themselves as concerned mothers, like this slogan that is here, how you call it, the pancart there, which is written by a concerned mother who says, "I do not want to be parent one or parent two. Don't discriminate me." So because the law that was proposed was to make no difference between parents and say that, they can be parent one or parent two, but not exactly just mother and father, and it was seen as a precondition to enter, the debate about a same-sex marriage, so this was one of the slogans saying that we do not want this in our society. Whereas the gay pride is usually attended by younger people, it's more colorful, and people there have slogans which, how to say, emphasize the diversity in a society, which is also seen in these mottos that are presented here. Still talking about the protest organized by the church, what struck me most was the way how the head of the Orthodox Church, allowed himself still to speak in the name of women, like it's still the Middle Age, So, and he said, women do not want fake equality and fake rights. So these are the words of the head of the biggest religious community in a country, a post-socialist country where religion was not that important some years ago. But again, yeah, now it's becoming more and more important. And another how to say, declaration during that protest was also very important. It was said by Bishop Jakov Stopski, so another person from the clergy, the Orthodox clergy, who said that for the sake of 1% of the population, the rights of the other 99% are undermined. And he called this a dictatorship. So the way how the anti-gender movement sees gender equality rights here in North Macedonia is that they distinguish between the majority, which they usually say it's a silent majority, and which is actually, how to say, maltreated by this minority of political elites who are usually puppies of the rotten West. So that's the narrative that is usually used. What is important in this regard is the relation that this anti-gender movement has with populism, which might not be a direct link, as it was said before, but however they use sometimes the same tactics and the same narrative in what they want to achieve. There is a study that analyzes the populism in North Macedonia, and it's called The Populist Citizen, and why the citizens support populist leaders and policies in North Macedonia. And they find three main factors contributing to support for populist leaders in our country. The first one is the inefficiency of the political system to involve citizens in decision making. This was done before. It's still in some ways done. I mean, now the civil society is more involved, but it's not that much involved. And usually some controversial things happen, and citizens feel that they are not asked at all when some important decisions are made in the public. Sometimes this decision can refer to high political issues, such as the name of the country. We had a very big name dispute with Greece, and now we have the same with Bulgaria, which confronts the identity of the Macedonian people. But however, these things tend, I mean, many people tend to think that these political issues are settled in how to say, in a way that does not involve the citizens. So that is one of the factors contributing to populism. The other one is, and it is misused by the opposition party, which is not now in power, but which is the right-wing party. They misuse this inefficiency to include all citizens in decision making, which is obviously impossible in all decisions. The second factor that is important here is the susceptibility to conspiracy theories among the population. The study has found that people who believe more in conspiracy theories are prone to support populistic leaders in North Macedonia. And there is this strong distrust in the institutions of the political system, which is something related to the past, but also very present in this time. And also another study that I've cited in this paper is the study Who is Afraid of the Gender? which actually makes the link between populism and the anti-gender movement, saying that contemporary anti-gender discourses are identical to populistic discourses, particularly in one essential point: understanding the world as a dynamic between the majority of gender normal, natural people featured by anti-gender movement and the corrupted, morally devious elites propagating then gender ideology. So that's maybe the main link between populism and gender equality. I have one part of my study referring to these kind of movements in Hungary and Poland, but because the previous speaker spoke in details about that, I will pass and go directly to the approach towards the gender-based violence in Republic of Macedonia. Um, Also, I would like to say a few words regarding to that and refer to what we had before and make a comparison to what we have now. So Macedonia actually signed the Istanbul Convention back in 2012, I think it was, but they did not ratify it until 2017. So we needed a change of power in order to ratify this convention because it was seen as a delicate issue. The previous right-wing, how to say, leadership of North Macedonia did not refer to gender identity and sexual orientation at all. So even in criminal code and in the anti-discrimination law, they were referred as a marginalized group of people, not referred to as sexual orientation as a ground for discrimination. So just a participation in a marginalized group, in marginalized community. With the change of government and the coming to power of social democrats, of course, this was changed because the activists supporting sexual orientation, LGBT rights, and so on, they played a major role in, in what we call the colorful revolution and what happened to, to come out of that state capture moment that we had before and, create a new, more democratic government. So that changed. Of course, the Istanbul Convention was ratified, a specific law on violence against women was adopted, and in 2023, amendments to the criminal code were done in order to implement the obligations that derive from the Istanbul Convention. It took a lot of time. Again, from 2017 when we ratified until 2023, it's 6 years. It's this perception that things are changing very slow and maybe very symbolic, because the idea is that you can change the laws, but in reality, again, the protection from gender-based violence is still not where it should be in a democratic country. So the main legal amendments of that came to power after the adoption of the ratification of Istanbul Convention was a new definition for the rape. Until 2023, we did not have non-consensual sexual intercourse as a basis for rape. It was only violence. The violence was there as an important element of the crime. We left that behind, with the 2023 amendments, and now we have that. If you use violence during a non-consensual sexual intercourse, then it is an aggravated circumstance. But the lack of consent is what makes the crime a rape. So apart from that, previously, apart from that, we introduced also new incriminations such as female genital mutilation, stalking, sexual harassment, all with this law that had in mind to implement the obligations deriving from the Istanbul Convention. But we know that a very important part of the Istanbul Convention relates to data collection and having reliable statistics on gender-based violence. So in our country, this kind of data is collected only for crimes that were previously referred only as domestic violence crimes. Now, the new criminal code makes a distinction between domestic violence and gender-based violence. Usually the same crimes are, becoming aggravated when they are perpetrated as an act of gender-based violence or domestic violence, but there is a distinction now. But however, our statistics are still old and they refer only to domestic violence as a form of gender-based violence. And in these statistics that I just shared with you, you can see that usually women report only physical violence, more physical violence, a little bit of psychological violence, but not at all sexual violence. So sexual violence is very much underreported as a domestic violence crime. And now for gender-based violence, we don't have yet statistics that will relate directly to these crimes. So these are some of the problems that relate to the thank you, to the data collection in regard to gender-based violence. And yeah, I think we might do well to raise the awareness into reporting more sexual crimes and to build up a reliable data system that will include all phases of actually reacting towards gender-based violence crimes, and not only reporting them, but also what happens after they report it and how many cases are prosecuted and how many indictments and judgments are actually received for these kind of crimes. Shortly, only for gender-based hate crimes. In general, in North Macedonia, we have a problem with underreporting hate crimes in general, but sexual orientation and gender identity hate crimes are the least reported from all. This is a comparison of what we have as hate crimes incidents in North Macedonia. So the picture below is with all hate crimes incidents reported in North Macedonia. And you see the picture above is the sexual orientation and gender identity hate crimes reported, which are very, very few. And it's usually that this kind of crimes are not reported within the official reports to the police, but these reports are derived from NGOs that actually work in this field. So there also we have a big problem of reporting gender-based hate crimes. And those who report these kind of crimes are usually, they are usually victims of secondary victimization and continuous victimization, because when they decide to go to court, it's a very long process and it's a very harmful process for them, because they have a lot of pressure from the perpetrators and from different gender groups. So in conclusion, I can say, yeah, three things. In my paper, I found that there is a significant constitutional degradation of human rights and liberties, which is visible in countries ruled by right-wing populist coalitions, as it can be identified in today's EU states, but also in North Macedonia. It was very vivid in 2006 to 2016, but it still has the consequences even now, even after the change of government. Raising awareness, and that it's usually all this, there are usually these kind of rights that may be generated after populist leaders such as that. They are very easy to be drawn back once the coalition, a populist coalition comes again to power. Raising the awareness is important, not only among women, but also among state authorities, legal practitioners and researchers, in order to encourage reporting of sexual harassment and sexual violence in general, and specifically sexual violence among intimate partners, and addressing properly the gender-based violence through the prism of hate crimes, and as a response to the socially constructed gender roles in the society, is a fundamental requirement of all gender equality and non-discrimination. So this was my paper, and thank you for your attention.
Thank you so much, Besa. Terrific presentation. All right, let me um, give the floor to Chiara Correndo. No PowerPoint, right? Excellent. All right, let me minimize this and get back on this.
Thank you. Okay. Is how women's rights in India are shaped and curtailed, in this case, through the rhetorical weapon of customary law, and how, according to this narrative, women's rights would be a threat to customary law. I must say that the gradual erosion of democratic institutions in India has been underway for quite a few years now. I'm thinking not only to the vigilante violence against minorities, the draconian laws meant to quash political opponents, or the so-called jungle Raj, which is extra-legal violence, encounter killings, violent repression of protesters. When it comes to women's rights, the discourse is a bit more slippery, especially if pitted against the decade-long BJP rhetoric, according to which the BJP is the women's rights champion. Think, for example, of the whole UCC issue posed as a women's rights issue. There is a great deal of literature about judiciary and institutions refraining from intervening and taking a position whenever it comes to women's rights as against personal laws. There is no literature or very little when it comes to women's rights as against customary law, especially tribal women's rights. Tiplut Nongri, she's a very famous tribal feminist scholar in India, has been particularly vocal on this point. She said that adopting a blanket policy shielding customary law from reform can only reinforce patriarchal patterns of power. And she said that this deferential attitude on the part of the judiciary and institutions towards customary law violates women's rights and excludes women from the enjoyment of several rights, among which political and economic rights. I'm presenting today two cases related to this issue. The first one is a very recent judgment adjudicated in December 2022 by a division bench of the Supreme Court. In this case, the appellant, she's the niece of a scheduled tribe member, ST member. She claimed to be entitled to a share of the compensation amount remitted to Aramco for the acquisition of a piece of land on the part of the Odisha government. That sum was paid to 4 nephews and she was excluded. She said, okay, I'm an ST member. I know that because of that, customary law should be applied to this case. In customary law, Adivasi, tribal customary law, is patriarchal in nature, therefore excludes women. I also know that Hindu law in this regards provides more safeguards, okay, but at the same time, Hindu law excludes from its application tribal women. I'm aware of that, but please, court, apply the Hindu law to this case. That was her claim. The sub-district court said no. They rejected the claim. They said the act is not applicable to ST members, so we will apply customary law. And the Odisha High Court confirmed this stance. At the Supreme Court, the counsel for Kamla Neti, she's the appellant, said she is entitled to this share, even if this means applying Hindu law to a tribal woman. Refraining from doing this would be a blatant violation of Article 21 of the Constitution and the violation of women's rights expressed in the court's doctrine. If we read the judgment, the discomfort of the court is palpable. The Supreme Court decided to adopt a very regressive interpretation of judicial precedents which could have been used for the advancement of tribal women's rights, and the court refrained from doing that. The court said, Hindu law is formally not applicable. It's not for the court to amend the law, so we send the question back to the legislator. Okay, basically they said, we don't want to have anything to do with that, even if this lacuna, and I'm quoting, is bad in law and cannot be justified in the present scenario, we still apply tribal customary law, which is patriarchal in nature. The second case I'm going to tackle is quite complex, so I'll do my best to summarize it. And it involves the Naga Mothers Association, which is a grassroots women's organization in the Nagaland tribal state in India. So Nagaland tribal groups have been opposing women's reservation in local bodies of governance for decades. They have been thwarting the elections, claiming that reserved quotas for women violates customary law of the Naga tribe. Okay, and they said Naga customary law is protected by the Constitution under Article 371A. Okay, I'm quoting the Naga Ho-Ho, which is the apex tribal body of Nagaland. We respect them as mothers and sisters, but as per our customs, we don't allow them to have political powers. Okay, so according to the Naga tribal groups, that's customary law. Customary law is there. sanctity of customary law, so it cannot be undermined by women's participation in political bodies. In 2009, the Nagaland government postpones elections indefinitely because they didn't want to face the protests of the Nagaland tribal groups. So the Naga Mothers Association decides to petition the High Court in 2011, seeking to stay this decision. Okay, the court ruled in favor of the Naga Mothers Association, directing the state to conduct election. 2012, the Legislative Assembly of Nagaland exempts Nagaland from constitutional reserve quotas. So there is a constitutional provision granting quotas for women. The Nagaland said, we are exempted. Our women do not fall under this provision. Okay. In 2012, a Kohima division bench of the High Court upholds this decision. The Naga Mothers Association 2016 said they approached the Supreme Court. The Supreme Court delivered a friendly judgment and ordered the state to organize elections. March 2023, the Nagaland State Election Commission announces election to 39 urban local bodies with reserved quotas for women. And you may say, finally, the last chapter. No, because on March 30, 2023, following opposition from tribal groups, the State Election Commission cancelled the election. And this happened 2 days after the repealing of the Nagaland Municipal Act, which grants these reserved quotas to Nagaland women. So the Naga Mothers Association files a contempt petition to the Supreme Court, and in April, the Supreme Court stays the Nagaland notification of polls cancellation. So that's the state of affairs now. This case is still going on. The Naga Mothers Association has received threats for her engagement in this legal battle, has been denounced as unmandated, has been denounced as a dangerous for tribal unity, but they have been decrying loudly the absence of women in decision-making, policy-making bodies in Nagaland. Think, for example, that in the whole history of Nagaland, only 2 women made it to the Legislative Assembly and only 1 woman made it to the Union Parliament. And Tiplut Nongri, the scholar I was talking about, she's been very harsh on this point. She said, even when women manage to get a political position, she questions the effectiveness of this participation. She called it proxy participation, tokenistic inclusion. And I must say, this quite confirmed the findings of my fieldwork. I conducted some interviews with women's heads of official panchayats. I participated in no-man panchayats, and in that all-man panchayats, they were pointing, they were selecting the name of the women's candidates. So there were no women, they were not deciding about their electoral future. It was men deciding about them. Even more interesting, and that's my last point, it is quite paradoxical, the fact that tribal women don't even manage to participate in local governance bodies in an historical time for India. And why am I saying that? Because it has been recently approved, and when I say recently, I mean 2 weeks ago, okay, an historical piece of legislation called the Nari Shakti Vandan Adhiniyam, which can be roughly translated as the Women's Reservation Act. It's been there for decades, and they finally approved it almost unanimously. This law reserves 1/3 of seats for women in the Lok Sabha, which is the lower chamber of parliament, state assemblies, the Delhi assemblies, plus provides the quotas within scheduled castes and scheduled tribes seats. There is no quotas for Muslim women and other backward classes women. So given this very recent development, I will try to provide some insights, let's say some starting questions for future research. This step, I mean, the women's reservation law is a very important step for women because it's increasing undebatably women's visibility in the public space, in policymaking institutions, but it should be analyzed, in my view, in the framework of the BJP policy, because the BJP claimed for himself this victory. They said, because women's empowerment features in 2014 BJP manifesto, it's our victory. In this manifesto, women's empowerment is broken down as reduction of rates of crimes against women, increasing female education, women's employment, a constitutional amendment to allow 1/3 reservation. So that's women's empowerment according to the BJP manifesto. But if we read the news, we will see that, for example, there has been a rally by the All India Democratic Women's Association protesting against the rise by 42% in crimes against women. And they pointed the fingers against the BJP chauvinistic policy, which increased the hatred against especially minorities, women, Dalits, and tribal women especially, which hardly hit the news. If we look at the labor force participation rates on the overall, it has fallen. But female labor force participation rate has increased, and the BJP says it's our victory. Yes, but it has increased in the agricultural sector, for example, which means poorer wages, low productivity, exploitative work contracts. Plus, there has been a massive shift of women from salaried to casual employment post-COVID pandemics. So not exactly a victory. I'll close with a provocative remark by making reference to an interesting article by Zetterberg and Bjorngard, who underlined that of the 75 countries that have adopted gender-based quota laws for parliamentary representation, 2/3 of them have been ruled by non-democratic government. And they mentioned the example of the Rwandan parliament, in which 61% of seats are occupied by women. And Paul Kagame himself won the Gender Equality Award in 2006 and 2016. They say, quote, autocrats are more likely than their predecessors to adopt gender equality reform to boost regime legitimacy when shifting attention away from violations of electoral integrity and human rights. So exploiting women's rights to gain domestic legitimacy and projecting a modernizing image to the outside, bringing about what they call autocratic gender washing, which often comes with control over women's rights activists, for example. And that's absolutely true for India. There has been an increase by 190% in the number of tribal women charged with sedition since Modi came to power. And most of these women are activists protesting against displacement, protesting against military violence going on in the mining belt, which is my area of study. So if we think of the data I was talking about, the everyday practical working of female participation in politics, the Nagaland repealing the act, the court upholding the Nagaland decision, or the proxy participation of women, or again, the courts adopting a regressive interpretation of judicial precedents to curtail women's rights, as it's the case with Kamla Neti judgment. These facts, at least cast a shadow on this new law. And my question is, can India's brand new law be read in light of this autocratic gender washing paradigm as well? Thank you.
Thank you so much, Chiara. Absolutely terrific. I propose that we take a 10 minutes comfort break and that we reconvene for our last two speakers and for the Q&A. I'll see you all back here in 10 minutes. Welcome back for the last segment of our panel. And may I please give the floor to Gergana. Thank you so much.
Thank you very much. And I would like to say very quickly, thanks to the organizers of this excellent workshop and to the panelists, and thank you for having me here today. So the paper that I'm going to present today is part of a bigger research. I will say just a couple of words about it at the end. The paper has been, let's say, inspired by the fact that in many countries, legislative and policy efforts to address phenomena such as gender-based violence and domestic violence are under attack by populist parties. And rather than emphasizing the need to prevent violence against women, these populist actors are frequently redirecting the conversation towards preserving traditional family values and structures and framing their position again as a defense against a perceived dangerous gender ideology. So my paper aims to explore how gender-based violence and gender-related concepts are present in populist discourse by both right-wing and left-wing parties in Bulgaria, and whether gender concepts intertwine with populist messages within the said discourse. A little bit about the timeline. I briefly touch upon the discussions surrounding the failed ratification of the Istanbul Convention, which happened in 2018, before delving into more recent developments, specifically the debates about proposed amendments to the Protection Against Domestic Violence Act in late 2022 and 2023. I'm examining two parties in particular, Revival, which is the right-wing populist party, and the Bulgarian Socialist Party, which judging by its name, should be a leftist structure. The case study of Bulgaria relies on methods such as desk research and qualitative content analysis of official party sources, such as party documents, positions expressed during parliamentary campaigns, interviews of party leaders, and articles published on their social media channels and official website. A little bit about the conceptual framework. I'm not going to repeat these because they appeared in several of the presentations today. The definition of populism, the characteristics of anti-gender campaigns, which have been widely studied by many scholars, increasing number of scholars, which is a positive development for sure. I just want to mention two things because they're directly related to this project, because I relied on previous research performed by Cantul and Lombardo about the strategies utilized by right populist parties. They were studying European parliamentary debates. So they identified the following strategies: direct opposition to gender concepts, rejection of gender equality and references to gender ideology, as well as indirect opposition, which might manifest itself in three ways. Firstly, bending gender towards other issues, such as migration, for instance, depoliticization, including through recourses to biology, and self-victimization. Importantly, for the paper on Bulgaria, I also relied on the analysis performed by Graf. She presents a very interesting analysis of the characteristic of anti-gender discourse in Central and Eastern Europe. For instance, she argues that the success, let's say, of anti-genderism in some of these countries should be attributed to the relative weakness of women's and LGBT movements in the region. She also finds out that gender is often linked to the Soviet past of the countries in this region. Thirdly, that anti-genderism is presented as a defense of traditional values, something which we also discussed today. And fourthly, and importantly, that in Central and Eastern Europe, the use of anti-gender rhetoric is common by ruling parties. Importantly, actually, Graf claims that only in Central Eastern Europe, but also in Italy, anti-gender rhetoric is used by ruling parties. In the case of Bulgaria, in 2018, the Bulgarian Constitutional Court ruled that certain provisions of the Istanbul Convention contradict Bulgaria's constitution and stopped its ratification. This dealt a blow to women's rights, as the current national legislation cannot match the convention in any way. In fact, any changes to the criminal code or to the Protection Against Domestic Violence Act that have been adopted since 2018 have been widely described as cosmetic. In 2021, the Constitutional Court again dealt a blow to women's rights activists in Bulgaria, saying that, ruling that in the Constitution, the word sex should be understood only in its biological sense. And in fact, it's related to a pure linguistic problem, which has been characteristic of the situation in Bulgaria. So unfortunately, in Bulgarian language, there are no two separate different words for gender and sex. This problem has been exacerbated by a major negative consequence of the anti-Istanbul Convention campaign. Gender is now widely used as a parodic and derogatory noun to mean a person with no clear sexual orientation. So basically, it is used in this way. I meet someone and I can say, you are a gender. Very troubling is the fact that largely due to new and much needed changes to the Protection Against Domestic Violence Act, they have been delayed, mostly because of political crisis, but also to a very successful anti-gender campaign. In fact, the authors of the report, The Tip of the Iceberg, which we discussed today, in an earlier report, they mentioned that the anti-gender campaigns were especially heavy in Croatia and in Bulgaria, but in Bulgaria, the campaign was successful in contrast to Croatia. A little bit about the findings that I produced after the analysis of the party statements and the party documents. The Bulgarian Socialist Party has been more active compared to the right-wing revival when opposing attempts to introduce legal and policy measures that closely align with the Istanbul Convention. It's important to know that even the convention is not ratified, there is a constitutional court decision, its specter still is present in debates. So whenever there is a debate about domestic violence in parliament or in the social sphere, immediately many people show up that say that actually this is an attempt to bring back the Istanbul Convention in some hidden secret form through a legislation of some sort. During parliament debates, both parties, so the right-wing revival and the left-wing Bulgarian Socialist Party, fail to address the importance of tackling gender-based violence or a domestic violence. And yes, they say that the changes their opponents propose are a covert attempt to introduce the Istanbul Convention. The analyzed discourse prominently positions anti-genderism as a defense of traditional Christian values. The link established by revival between the traditional Bulgarian family and Christianity is not as straightforward as the one articulated by the Bulgarian Socialist Party. However, it becomes more intriguing when we explore messages and tropes that carry populist undertones. Revival more skillfully employs such tropes. For instance, they say that introducing the Istanbul Convention or similar legislation will allow foreign actors to come and abduct Bulgarian children, which will be taken mostly to the Nordic countries. And they refer to these actors and their helpers in Bulgaria, which is the civil society. They refer them as janissaries, which is practice from the Ottoman Empire, where Bulgarian children, not only Bulgarian, but children from Christian peoples were taken to serve in the Ottoman army. So this is something quite often mentioned by revival. These numbers here represent the times where the strategies identified by Cantula and Lombardo were used in parliamentary debates on changes to the Domestic Violence Act or on the Istanbul Convention. So we see that the direct opposition was the most frequently employed strategy, followed by indirect opposition through self-victimization, indirect opposition through Euroscepticism, which is more pronounced for revival, which is openly Eurosceptic and pro-Russian, and then indirect opposition through depoliticization, and at the end, indirect opposition through bending to other issues. I also found three other strategies that were not identified by Cantula and Lombardo. Maybe they're more characteristic of the Bulgarian discourse, although I noticed that they also appear in other countries. So firstly, opposition to NGOs, I mentioned about that. This is especially pronounced for revival, which see in the Bulgarian NGO sector basically an instrument of the European Union, the USA, foreign influence, and so on. This is followed by two strategies that are more frequently exploited by the Bulgarian Socialist Party. The children will suffer some kind of harm because of these changes, and very importantly, children will be given the option to report on their parents and be taken to Norway. Furthermore, both the Bulgarian Socialist Party and Revival employ anti-gender rhetoric, framing their messages through a populist lens. The current leadership of the Bulgarian Socialist Party attempts to portray the party as a protector of Bulgarian and Christian life, morals, and culture, as a guardian of the rule of the law, and of the will of the Bulgarian people whose children are put at risk by the Istanbul Convention. Revival's anti-gender rhetoric is intertwined with the Eurosceptic and populist narrative that emphasizes the necessity of safeguarding Bulgarian identity against perceived foreign interference. To a great extent, the analysis sustains the view that the fight against gender ideology, and in the Bulgarian case, against this pressure from abroad, can be the glue binding together right-wing and left-wing political parties. It also needs to be mentioned something else, that the propagation of such misleading narratives, such as, for instance, that the Istanbul Convention is related to adoption by same-sex couples or same-sex marriage, this would not be feasible or politically advantageous if there wasn't already a significant audience that is highly receptive to misinformation and manipulation. It is enough to mention, in the case of Bulgaria, but not only, anti-vaccine sentiments, COVID-19 denialism, variations of the great replacement theory. So many studies have shown that actually the publics, the audiences that are receptive to these messages overlap. The convergence of left-wing and right-wing parties playing the populist card, at least as extracted from this case, can be attributed to both the belief that populism offers an easy path to greater political power, but also to the realization that certain disinformation narratives have already effectively infiltrated society and are very, very suitable to be used for political purposes. Last but not least, two potential avenues for future research. Firstly, there is a need to investigate why misinformation and disinformation narratives centered around stereotypical and degrading depictions of women are so good at infiltrating society and gaining popularity. It is also crucial to understand why Bulgarian society still lacks a comprehensive understanding of the gravity of the gender-based violence phenomenon, and this is something widely and freely exploited by populist actors. Secondly, and building upon Graf's observation about the relative weakness of movements in this region, maybe we should study the discourse and counter narratives that have been employed by the Bulgarian civil society, but also by other actors. The underlying reason is that in order to combat gender stereotypes and implement effective policies that address violence, it is imperative to foster a vibrant civil society capable of presenting compelling counter-arguments. And very briefly about the project that I'm implementing, it's a two-year Horizon 2020 project implemented at Ca' Foscari, and it centers on two phenomena: gender-based violence, especially violence in the digital realm, but also gender disinformation, with a focus against gender disinformation against women in visible positions. Thank you very much about your attention and your time.
Thank you so much, Gergana. A really fascinating presentation. And let me move on to our last but not least speaker, Chiara Magneschi, and then we'll have a Q&A.
Thank you very much. And thanks to Professor Stradella. Are never too many and are never circumstantial. And thank you to the conference staff who were very supportive. I will try to establish a connection between democracy, populism, Italian constitution through the care, in a philosophy of law perspective. In recent years, constitutions, I refer in particular to European ones, seem to have lost their role as unquestioned axiological reservoirs. In this, populism plays a decisive role, with his claim of a counter-trend positioning with respect to substantial equality between subjectivities, to a democratic culture which is thought as hegemonic and ideological. The complexity of contemporary times generates a big disorientation that is exploited by certain political exponents to advance a protectionist and paternalistic response through the recovery of ancient hierarchies. This protectionist model also clearly has a patriarchal matrix, as was recently reiterated by Lucia Re, since it is declined as the exaltation of the traditional family with the placing of women under protection. The urgency of renormalization has the effect of afflicting some of the fundamental constitutional principles and rights, pillars of the democratic order, such as gender equality, a principle that, starting with Article 3 of the Italian Constitution, has been materializing very slowly from the post-World War II period to the present. In contrast to this decades-long path of civilization, the directions claimed by populism have already influenced political choices, such as the Italian government's rejection of PNRR funds for the implementation of daycares and kindergartens, just when, for the first time in Italian history, the Prime Minister is a woman and a mother. However, in some cases, the constitutional charters do not appear to be sufficient to keep up with societal developments, and therefore may lend themselves to ambiguous and regressive interpretations or even favor them. Sometimes, in fact, the arrangement they crystallize seem to slow down the path of rights. The choices of the constituent fathers sometimes could not to penetrate the limit of the cultural horizon proper to that era, ending up consolidating systems of strong inequality. This is the case with the Italian Constitution and its Article 32, as we'll see. So it is true that populism aims to a monolithic affirmation of identities, but it is also true that such identities are often rigidly fixed already in the constitutions. Care and the Italian Constitution. Article 37 of the Italian Constitution states, "The working woman has the same rights and, for equal work, the same remuneration as the worker. The working conditions must allow the fulfillment of her essential family function and ensure special adequate protection for the mother and child." In other words, the fulfillment of family tasks is mainly, if not exclusively, the responsibility of women. These provisions were the result of a rather heated debate in the Constituent Assembly among ladies and gentlemen. The women went to great lengths to affirm a principle of formal as well as substantive equality between men and women in working conditions. Some female speakers had objected to the use of the adjective essential, referring to that family function, because that it would enshrine a traditional principle now outdated by economic and social reality, which circumscribes the activity of women within the family. The response of the male speakers was conservative. The reference to the essentiality of the family mission of woman be a necessary start and clarification for the future legislator, so that it keeps in mind the tasks that characterize her life in a peculiar way. And again, the function of woman, as long as the family exists, is predominantly within the framework of the family. The work and functions that a woman must exercise as a mother and as a wife prevail over those that she can exercise as a worker. Statements such as these generated the still current wording of Article 37. An article that thus seems formative for the preservation of a patriarchal arrangement, extremely appropriate, moreover, as a populist slogan. Indeed, the use of the adjective essential and its resonance with that essentialist view that is the sap of populism is striking. It authorizes and makes authoritative as absolute truth the innate competence of women to family care and their natural place in private space and outside public space. A norm constitutive of a precise order that also makes adverse the contribution of jurisprudence in the construction of alternative and equal models. There is evidence that from 47 to the present, there have been no pronouncements of substantial affirmation of co-responsibility for care, as Ruth Rubio Marin has pointed out. So the Constitution, which called the privileged antidote to the for populism, constitutes one of its main allies, changing the lexicon so that it clearly expresses the centrality of care co-responsible in the system as duty and as rights of all and all beyond gender, is certainly one of the most incisive paths of the affirmation of substantive equality. This is how, among others, Anna Maria Despug expresses herself, the care collective too, etc. What is needed is the highest possible consecration of this new principle, calling each person to occupy that space of care. Among the possible implementations of it, there is, for example, the measure of mandatory parental leave for fathers. There is need to start again from the legal system foundations, from the words of the Constitution, bearers of crucial meanings. Care and democracy. The same reservations can be moved toward the ability of constitutional states of law to offer these defenses. It has been noted that the structure of liberal constitutional states is inherently hierarchical. Their genesis is often violent and characterized by superiority-inferiority relations, the subalternity of which patriarchy hinges simply constitutes a continuation of this genesis. At the same time, populism exploits such hierarchical arrangements by proudly bringing them out into the open. A vicious circle is thus created and poses a great danger to the resilience of international constitutionalism. As Feynman states, institutions really must take substantive equality as the beacon of their action. How to achieve this? There is not just one way, but surely one of the main way is to have the idea of care equally distributed among all subjects, penetrate all levels of the legal system. Care must be the basis of a democratic living together. To address the crisis of contemporary democracies, it is appropriate to move from democratization of care issues. This is the proposal of John Tronto, who suggests struggling for the construction of a democratic care and democracy that has care. Giorgia Serughetti has similarly expressed herself. Democratic deficit and care deficit are closely linked, as Nancy Fraser has pointed out. Politicizing care means not only making it visible as a public issue, but also valuing it as a fundamental activity that gives meaning to human lives and contributes to building a common world. The convergence of political freedom with practice of care is capable of strongly reinforcing democracy against the winds of populism. Indeed, populism gathers support because it effectively intercepts a demand for care, but it responds with a protectionist care. That is, it reserves protection only for the strong identities. The theme of care relates directly to that of the vulnerability of human beings. Populism interprets it as a sign of weakness instead of an asset. For Feynman, as for Butler, the heart of the principle of equality is a conception of the human condition as vulnerable and interdependent, in need of care and caring. Starting with classical liberal ontology, the subject is conceived as unrelated, independent, self-supporting, to the point of an exaltation of a person's ability to make it on his own. But such a position turns out to be illusory. The common exposure of human beings to violence is also the basis of contractualist theories, but these aim to reduce it through legal immunization and remove it from the political horizons, in the words of Lucia Re. Conclusion, constitutional values are no longer as unassailable as we used to believe. At the same time, there is a need to reformulate some principle so as to make them stronger. First and foremost, that of the equitable division of the burdens of care, which encourages a renewed sensitivity, in the belief that the occupation of care spaces by everyone is one of the points of re-beginning for democracies. The way to deal with that crisis must be political, but also theoretical and semantic. A reflection that deconstruct and resignify the constitutional dictate, which is not afraid to reflect on possible modifications of it, proved to be indispensable. It is necessary for the Constitution first look at all its recipients as caregivers and cared for. A Constitution that also legitimizes emotions, vulnerabilities, and particularly the conflicting and the complex ones arised by caring. Working in and through ambivalent emotions and empathy is one of the keys to building democratic communities. Thank you all.
Thank you so much, Chiara. So I would like to open the floor to questions and comments. Anyone, before I start abusing my chair's position? Okay, I will start by abusing my position then. All right. I have a first question that I think cuts across three of the papers, and it's a question about context. So I'm wondering to what extent the post-Soviet transition affected the framing of gender constitutionalism, in the case studies that we've seen, that Alessia, Besa, and Gergana presented us with, and how that's used in terms of rhetoric and whether it has any reflection in constitutional discourses.
Well, in the case of Bulgaria, it's I would say that mm, I don't know to what extent Soviet and how it influenced it, because one of the parties that I studied is the Bulgarian Socialist Party, which still fails to disassociate itself from the Bulgarian Communist Party. So they celebrate 100 years of their founding, 110, and so on. So they're nominally the successor of the Communist Party, which was anti-religion. Of course, it was, pro-equality on paper and so on. But at the same time, now the Bulgarian Socialist Party demonstrates a very close affinity to the church. So the leader of the Bulgarian Socialist Party, I think she's there every month, like seeing one of the patriarch or and discussing gender. So I would say that in the case of Bulgaria, I don't see a direct link, especially one of the most vocal opponents of the gender equality debate and so on is the Bulgarian Socialist Party. But I would say that probably the link is still the failed democratization process, and something that we have been discussing with Bessa now, that and I hope that maybe she can elaborate on this as well, that the parties that are currently they're abusing democratic instruments and exploiting the fact that they're in some kind of a democratic environment in order to propose anti-democratic practices, language, and discourse. That's the first observation I have.
Continue. Case of Republic of North Macedonia, it's again interesting to see how that developed after the communism ended. And actually, the party that came up after the Socialist Party is actually the Social Democratic Party. That's one of the two bigger parties, and it's considered more like a center left-wing party. And the other party is the Vămăror Pomone party, which is a center right-wing party, but they are more right-wing in that occasion. And when it comes to the gender identity issues, again, the Social Democrats are, although coming from a socialist background, they are more tolerant and more acceptable of this kind of diversity in their narrative. They have always been like that, and especially during the last rule, beginning from 2016 up to now, they have been prone to address these issues, to go further with the ratification of the Istanbul Convention, and with all these new developments, at least in the legal field, that they have become a reality. So, but on the other hand, they are undermined from this, anti-gender narrative, which is more related to the right-wing party, which is not a party that derives from the socialist background, but they use this kind of narrative a lot in regard to actually oppose the rule of the Social Democrats as a rule, and that's the terminology that they use, the rule of the minority over the ethnic Macedonian Orthodox majority. That is something that is used as a narrative throughout North Macedonia in all political developments, and it also reflects the gender rights and gender, movement in North Macedonia. And another thing that is important there, in 2016, when there were these, general protests against the former government, the LGBTI movement and gender activists, feminist activists, they all supported the Social Democrats in regard to change of power. So that's why after that, there was this new reality where the president of the state, the president of the ruling party, the Social Democrats, they attended the gay prides, their celebrations and all that. It was not seen before. It was something that developed actually after 2016. So actually, in the case of North Macedonia, you should you should have in mind that it's a controversial, it's something controversial to what we had during communism and with the new, development of the Social Democrat Party. But actually, they are very undermined by this anti-gender movement narrative, which actually makes them look bad at before the populist citizen, which is a strong thing also in North.
Thank you. And I agree. I think that it could be applied also to Hungary and Poland. And I think that a heritage of their political past could be identified in the conservatism and the criticism of neoliberalism and globalization that today identify this new wave or right-wing populism, because today populism is different from the wave of populism in 80s and 90s, and it is and so there is a reason because populism is now spreading in Central and Eastern Europe, and I think the political path is a reason of that.
Thank you so much. Let me reopen the floor for any more questions or. Oh, yes, Ruth.
The narrative, of course, is that this is an indoctrination from a minority against the majority. In that imaginary, who is the minority that is imposing its values? Because ultimately, if you think, well, we're talking about women's rights, that's already half of the population, and of course, other groups that are being affected. So how much of this is internally, or is this just an elitist, Western, who is the minority in theory?
Thank you very much for this important question, and it's really disturbing, how to say, narrative, because actually it makes a distinction between women's rights to emancipation and all that, and to those women, if we may say, that actually support LGBT rights. And unfortunately, the gender debate is more and more concentrated around unifying the gender rights with sexual orientation rights. And for example, in North Macedonia, the protests that I mentioned, the protests were against the gender equality law, first of all, and then towards the civil registry law. So civil registry law is about transgender persons, accommodating them and their needs within the law. And gender equality law is a gender equality law between women and men to have the equal opportunities. But there is this, demonization of feminism in general and gender rights in general and gender equality rights, and their demonization and direct linkage with LGBT rights and gay rights, which is not in essence wrong, because these are the same things, when we talk about gender theories. But when they promote that, they promote it as as a theory presented by this minority of homosexuals and feminists, women that are not usually familiar women, women with families and with things like that. So not the conservative women, in that regard, but this minority of women who are usually, prone to be homosexual maybe, and so of that, and this 1% of people who, in their opinion, are not normal, as opposed to the majority of normal heterosexual and conservative women. So that's the majority in their regard. No.
And just one quick more follow-up. Because I thought this might come as your response to Mara's question, the rhetoric of neo-Marxist indoctrination. Is that something that comes in the region? I hear that it's lumped together, that feminism is presented as neo-Marxist indoctrination. If that's the case, there would be something about the socialist past to connect. But let me maybe, while I have this, and I promise I'll let go, ask a question to both Chiaras, actually. So first on Chiara Correndo. So I take it that the second case is still pending at the Supreme Court, right? But I had read that the Supreme Court had made some inroads about applying constitutional equality principles in personal family status issues. So how do you put the two together? Family status, religious minorities, we intervene, maybe because it's the Muslim minority that you're intervening against, and tribal people not. I mean, is that the reason? Can you elaborate a little bit on that? And then to C.Magneschi, I wonder, and maybe you said that, but I confess I was a bit tired, so I disconnected at times. So sorry if you already said this, but I know that in Ireland, which, as you may know, there is a constitutional provision that is much worse than Article 37 in the Italian Constitution in terms of the breadwinner family model. There is a very current debate about whether the provision should be removed, the provision that basically says that women should be assisted so that they don't have to work. It's actually different because they say they should be assisted so that they don't have to work and they can focus on their family duties, versus the Italian version, which is probably women should be doing both. But we have to make sure that they can do both. So the question is, I know that in Ireland, there's been a debate about whether this provision should be removed from the constitution or whether we should keep the provision but make it gender neutral. So because we want to put the finger on the relevance of care, we want to have that remain in the constitution, but it should be equally shared between men and women. And the question for me is a similar debate, doctrinal debate, taking place in Italy? I mean, were it the case that Article 37 would be, changed, would this be simply kind of a, we're not going to mention the family duties, or we're actually going to mention both men and women? Is there a similar debate in Italy?
May I jump in? Okay, thank you. Thank you all for these beautiful presentations. I'm just following up on Ruth, and I'm also referring to Article 37 of the Italian Constitution as well as the 34 of the Irish Constitution. So, in fact, there has been research so far about how to reappropriate these provisions. I think Julie Suk wrote about the Irish Constitution, saying that even though it is highly gendered, it still provided some protection in the end for caregivers in general. Well, yeah, I know, but the argument has been made that it provides some kind of protection to the value of care per se, even though in a problematic way. So by way of reinterpretation, it could be broadened. Something that has also been done, I think, in Italy, by the way, by Pezzini, who is, as we all know, an ardent feminist, but also has been very much opposed to the idea of reforming Article 37, saying, it might be gendered, might be reflecting another time and age, but it is also true that by way of this highly gendered provision, we still manage to have the protection of care, which can be over time interpreted in a more gender neutral way. No reform at all, no reform at all of the text. I agree. I very much agree. No, well, I mean, like, I don't want to misrepresent the point. My understanding of her point is that, but of course, take it with a pinch of salt because it's how I understood it. My understanding is very much not in a position, I mean, at least from Pezzini, not in a position in principle, but more of an opposition regarding the distrust that we have towards the specific Italian academic political elite. So being fundamentally incapable in the end to reform it in the proper way.
And then risking.
And then exactly. So exactly. I mean, it's not, I don't think she was opposing to it for the sake of opposing to it. Exactly. But one way or another, I think the point is that this highly gender provision, according to some, might protect some kind of might grant some degree of protection to caregiving, and in the end turned out to be more feminist. By the way, I was here at the seminar, well, not of EU Wonder, but LAN, when I proposed, when I was contesting Article 37, and there was, I think, quite a heated reaction, I would say, to
letting go.
To letting go, like well, no, this kind of.
I share that, and in fact, I mean, whatever Julie said, I don't know, but there is that symbolic recognition. But the truth is that the Irish Supreme Court has not been willing to derive any substantive rights from the care provision. So women have tried to say, well, make it true, give me an enforceable right to some protection when as a caretaker, and that has not been the case. But I still think the symbolic recognition value, is still important. So, and we do have a motherhood protection, a motherhood protection tradition in Europe that I also, as you know, don't think we should let go, because I think we should reform it to include fatherhood, but not let go of motherhood in that sense. So yeah.
I mean, and this is, I think, the best part of the. I mean, it's Ecuador, it's Bolivia, it's Colombia, it's República Dominicana, all over, really, granting this heightened protection to care in constitutional law. So, anyways, so I wanted to know your. It became a discussion between the two, but I would like to know.
Let's give it back.
Exactly. No, but I would like to know better how you think whether it can be reinterpreted. These provisions can be reinterpreted in a more gender equal way. Sorry for hijacking.
I'll reply first. Two lines or answer. First one, there is a distinction that should be made between personal laws and customary laws. My assumption is that whenever it comes to customary laws and tribal issues, courts have been comparatively more afraid of intervening. They have been more wary because behind customary laws, there is the whole tribal issue. So they don't want to intervene in the tribal issue. They don't want to be accused of colonizing tribal communities with law and all that. If in personal laws we have a bit bolder attitude, in customary laws they are wary of intervening. Still, nonetheless, approaching the court is an empowering action for Adivasi women and tribal women. So that's still an important thing to underline. Also, I assume you're talking about the Shayara Bano judgment, probably. Okay. The Shayara Bano judgment has been presented as a big feminist victory, but in my view, if we read the judgment, we will see that, for example, the judges adopted the arbitrariness doctrine. They refer to the arbitrariness doctrine, to the essential religious practice test. They didn't make any mention to the structural aspects of gender discrimination. They reiterated, for example, a normative vision about marriage as something to be protected. So that's okay, that's a feminist victory, but how? What kind of reasoning the court followed? The same goes for another feminist victory, which is Shafin Jahan judgment, the love jihad judgment, in which the court directs the National Investigation Agency to control and to check if that was a fake marriage. So Hadia's choice was again subjected to scrutiny, male surveillance and male scrutiny. Yes, but how the court reached that kind of verdict?
Thank you so much. Yeah.
What I have noted in the allora don't exist for me don't exist really authentic debate on this theme. Don't exist simply. Lucia Re is one of the few voices that yes. Ciao Lucia. As
Ciao,
have
scusate, non
spoken
so se
about
era
spoken
autorizzata a
about
salutare.
this problem that has problematized this theme also in terms of political theory. But what I sense in the debate is the fear also among women to touch this article. Because reforming this article could signify to leave the peculiarity of women. Will take away from women this consideration, this legal consideration. I have heard these words in the few debates that I have seen. The question is perhaps linked to the dilemma between the feminism of difference and the feminism of equality. We know, for me, is false dilemma, but still is presently. I think that as it is now formulated, the article don't let hope or to be interpreted through an really authentic equality, substantive equality principle. At the same time, I don't think so. For me, it's opportune, it's good to remove that distinction, and the risk I don't think it's a good idea to maintain the particular treatment of women and of women's work also, because I think this bring to a division, bad division from between reproductive rights and productive rights. This is the theme of remuneration of housewives in Spain. Have been several rulings or pronouncement recognizing the right to remunerations for work done in the family at the time of separation from the husband. I will not go in this direction, maybe because it goes through the attempt to value care as being equated with productive labor. And I believe that the paradigm of reproductive and productive rights is different and must remain so, like this. I think this work must be taken to the politicians, to the political. And we have some good signs, actually. Some examples, little examples, but with significance. In Europe, for a while now, has been talk to decreasing the daily working hours to 6. Some countries are already experimenting with this. This allows more people to devote more time to care. It is yesterday's news that a large Italian company, that is Barilla, has introduced parental leave also for fathers of 12 weeks, paid at totally paid. Thus standing it compared to the Italian legislation that sets it at only 10 days. This with the motivation of reducing one of the principal factors of the gender pay gap. In these days too, Ellie Schlein, the Democratic Party secretary, has come out in favor of the 4-day work week. So good signs. After there are several of bad signs, but I don't talk about this. I prefer.
Thank you so much. Oh, more questions. Thank you.
Thank you very much to all of you. I think that this panel was very interesting, also the one in the morning, but like I really like the fact that we have people coming from different countries so they can share their own experience of like what's happening in their country. So my question is referred to all of you, and many countries in the world are facing backlashes about anti-discrimination laws and laws protecting women and minorities, as you have said. And my question is, do you think that our constitutions will be strong enough to face this backlash? And also, like the interpretation, the wide interpretation that we have done of laws for protecting women and minorities as well, will be still how do I say, like still there, or they will be reinterpreted again in the light of this new wave of populism, which is, as you have well explained, as a strong anti-gender and anti-minorities. Okay, thank you.
Thank you so much. That's a great question. I think that's really the point of this workshop. Who wants to go first?
In my opinion, it depends on the health of democracy, because I think that our democracy is stronger than other countries in, for example, Hungary and Poland. So obviously, a backlash is always possible. But I think the real question is about how it works, the political dimension. I think that we are experiencing a populist period also in Italy, and it is dangerous, but I think that our democracy and so our constitutional defense is stronger. So I believe in that, but don't know, maybe it's an hope.
It is definitely important to have a strong constitution, although I can say that, I mean, it's clear that the rise of populism has been quite strong in one of the most democratic countries with a very old constitution. So I would say that maybe adding to what Alessia said about the health of democracy, especially with respect to gender and gender equality, I think we should look for the answer in society and social change. Although maybe this is coming from my background as a political scientist, but really until the society doesn't understand that gender-based violence is a grave phenomenon, and until stereotypes that fuel these movements still exist, I think it's no matter how many times we change our constitution, because in Bulgaria there is currently an attempt to change the constitution because it's quite old, it's not going to change anything.
Yes, and if I may add, I mean, Gender backlash is always possible. And in case of Republic of North Macedonia, it is not that the constitution was particularly changed to accommodate this new rights. The constitution stayed the same, but certain laws changed. And laws can be changed very easily. I mean, before this law on gender-based violence was only called the law against domestic violence. So that was the only form that was accepted for the previous right-wing government. Then it became the law on gender-based violence. It can go back again to recognize only domestic violence as a certain form of gender-based violence. We never know. So what is expected in North Macedonia is that in the new elections, the current majority will have a difficult position, and maybe they will lose elections because they needed to to take some seriously and unpopular decisions in political terms, like the Prespa agreement with Greece and other issues. So that will maybe reflect to the elections, and everybody is expecting that the polls say that the right-wing party gains more and more popularity in that regard. So what I expect is two possible scenarios. Either they go back, to where they were before, which will be a bit more difficult because now the society is awoken, and gender activists and LGBT activists, they will not be very silent anymore, and they know that they have these rights, and it's more difficult to take out the rights that were given to them before. And on the other hand, in the other scenario, which is also very possible, is to accept this form of new reality that actually was done before, by somebody else. But now we cannot change it because we are in our way to integrate in EU, so we cannot go back to that. And it's something that the others did, but we need to to continue in that regard. So both scenarios are possible. Let us see what it happens a year from now. Yeah.
I think in the case of the Italian constitution, in this constitution, as I said before, is not strong. Is not strong. In particular, for my point of view, is worrying about the use of the natural, the adjective natural. This adjective is on the 37 article, but also in the 29 about a natural family based on heterosexual path. So this is the problem, the major problem. It's certainly the constitution had to fix some identities. No, it's physiologic. But in these cases, it is an irrecoverable closure, and choice that asphyxiating, that it makes the principle closed and already regressing from the start.
As regards India, Indian constitution is not feminist, nor is it particularly protective, even if the Chief Justice Chandrachud likes to believe it. As one author aptly said, feminism has to be read into constitution. So women approaching the courts, that in my view is the real engine of change. That is the push for change. And those 190% of rise in women arrested for sedition, those women are women protesting, are women taking it to the streets. So in my view, they will read feminism into constitution.
Thank you so much. Any more questions? No? Anything anyone on the panel would like to add? No? No. I was asking the speakers. We're 10 minutes early. Do you want me to wrap up? So just thank you so much to everyone. Sharp. I know. I've been instructed by tomorrow's first panel's chair to remind everyone that we're going to start sharply and precisely and punctually at 9:30. Thank you so much for everyone. It's been a terrific day. Thank you, Elettra. Thank you, Giovanna.